surveillance. Yeah. Okay? For the reasons of this search warrant. Alright? I'm sitting here and watched you and him and her.
Can't believe we get about 10 or 15 minutes. I'll be ready.
You looked up. Matter of fact, you did look up at the camera 2 or 3 times. He pulled the phone out and
A seemingly simple case in Blount County, Alabama, unexpectedly turned into a dramatic legal confrontation. 2 lawyers had just left the courthouse with their clients when they were stopped by police, who demanded to search 3 phones, even though the warrant only allowed them to search their clients' bodies and vehicles. As the 2 lawyers kept the phones in their bags, the police kept changing the reason, from executing a warrant to emergency situation, then to arresting the lawyers for obstruction of official duty, even though they calmly protested the unreasonable request. The climax was when the police demanded that the lawyers apologize and admit their mistakes in order to be released. As a result, the 2 lawyers were acquitted, and the police were sued by the federal government for abuse of power. The video clearly exposed the confusion and inconsistency of the police, in contrast to the sharpness and steadfastness of the lawyers. Watch the whole clip, and please support this auditor by subscribing to his channel. The link is in the description.
The warrants that you all have are for his person.
That's correct.
And for his vehicle.
That's correct.
So he has given the phone that's on his person. Okay, I have video of him handing the phone to you. You handing the phone to her. It's in the satchel right now. Yeah, you all do have that, but that is not on. When you all
no, I'm
came
out
on
here
him
at the courthouse
to serve
with
this
Brian on
warrant,
the search
that was
warrant.
not on his person. Okay. So you all are not entitled to that. Okay. Well, I can. We'll go the other route to get that other phone.
As Mr. Revel mentioned, the language of the search warrant dictates that the search may be performed on Mr. Edwards' immediate person and vehicle only. Since Mr. Edwards was not in possession of the phones at the time of the warrant being served, the deputies are not entitled to them. If the deputies had acquired a search warrant for the phones themselves, then they may have had some authority to seize them. But the validity of such a search warrant would be questionable, considering that the defense also intends to submit the phones as evidence. The search warrant presented by the officers does not authorize them to search Mrs. Garcia, but the prosecution does have a trick up its sleeve, which we will discuss later in the video. After realizing that Mr. Revel is refusing to comply with the search, Deputy Ashworth calls the district attorney's office for advice on how to proceed.
Hi, we're standing here and we have it on video that he handed his cell phone to his attorney, one, and they handed it to another, and it's in the satchel that is right here.
Well, are we being detained? At this moment in time,
They're not denying it. We have it on video.
I'm going to detain you until we determine the next course of action. Give me
Well,
just a minute.
what I have is
Okay.
person and vehicle.
I'm going to turn this off. I think what we just done.
Okay. Okay. We either need the phone out of the satchel, or we will have to detain you and get a search warrant to get the phone.
So you're going to, well, okay. Well, we're not going to give you anything that's on our person that you don't have a right to. So if you detain us, you have to have, there's certain constitutional safeguards to do that. But you're going to detain us, then hey, we're not going to run. So, and you all are telling us we are being detained. Is that right, Officer Rapp?
At this point in time right now, you are being detained. Now, if they determine.
Okay. You both are under arrest for obstructing government operations.
Obstructing government operations.
That's correct.
Ms. Ashworth.
This is definitely an unlawful arrest. But
I'm not sure you're in trouble for it. I don't understand it.
Clerk, if you would turn around, let me make sure you don't have no weapon on you at all.
of course not.
Okay. Just want to make sure.
We have it on video.
We have not broken the law. So if you're arresting us, I'm being arrested for obstructing government operations.
That's correct.
Let me take out this right here.
If you don't mind, take them copies. That way it'll be a lot.
Real nice. Y'all want to arrest 2 lawyers for this charge? You sure you
Are
want to
you
do this?
subject to the law?
I am subject to the law.
Under arrest.
Okay. And this is And who are you?
I'm Sue Ashworth, manager.
Sue Ashworth.
That's correct. And this is Brian Ratliff.
And you're arresting us under her orders?
Yes, sir.
Okay. Deputy Ratliff,
Yes, sir.
I want to make sure that you know from our position was that this search warrant, this warrant was given to him after he gave us some things for us to use in his defense. And so we did not
Good.
do anything to keep you all from doing you all's job. Now, if you all want to
I'm out
take
here
this
with
satchel and go
the
through
sheriff's
and do it,
office at the courthouse.
we're not preventing you from
Doing the search warrant on the car. And
so I just wanted to make
I'm out here just.
From the moment he's entered the courthouse, he's been under surveillance.
Yeah.
Okay? For the reasons of this search warrant. Alright? I've sat here and watched you and him and her.
Temple, if
Run
you give
the
me about
elevator.
10 or 15 minutes, I'll be ready.
You looked up. Matter of fact, you did look up at the camera 2 or 3 times. He pulled the phone out and handed it to you. You handed it back to him. He was fooling with, I'm guessing, a
I just
password.
want to keep you on the line.
And after a short period of time, he handed it back to you. You handed it to her. She put it in here. Okay? That is evidence for this search warrant.
And you agree with me that you all served this search warrant on him subsequent to that, after that, all right?
Yeah.
After we left out the building.
Yes.
The deputies fail to understand the authoritative limitations of the search warrant, and Mr. Revel and Mrs. Garcia were arrested and charged under Code 13A-10-2. The prosecution initially offered to drop the charges if Mr. Revel agreed to write a letter apologizing and admitting that the deputies did nothing wrong, but Mr. Revel rejected their offer and decided to proceed with a trial. In the ensuing criminal trial, Mr. Revel and Mrs. Garcia's defense argued that the state failed to establish the defendant's intent, and that no crime was committed because the search warrant did not authorize the search of Mr. Edwards' attorneys. The prosecution argued that they were entitled to the phones under the exigent circumstances doctrine, which is a legal precedent that allows for warrantless searches in circumstances where evidence has a high likelihood of being destroyed, such as cell phone data. I have covered the exigent circumstances doctrine in a previous video, which I will link in the info card above. During the trial, Mr. Edwards, who was still under investigation at the time, testified for the prosecution, but stated that District Attorney Casey tried to prep him in his testimony, even though she had reportedly recused herself from the case, and Mr. Edwards became a key witness for Mr. Revel's defense.
Thank you for watching police using vague justifications to stop, question, or detain people without cause is a growing concern. Simply being in public is not a crime, and officers cannot demand compliance without legal justification. Whether it's intimidation tactics, unlawful demands for ID, or escalating situations without cause, standing your ground and recording every interaction is key to holding them accountable. Always ask questions, challenge unlawful orders, and never let your rights be ignored. Subscribe for more U.S. police accountability videos, real encounters, and important lessons on knowing your rights. Stay informed, stay empowered, and never stop filming.